Welcome back to the deep dive. Today we're tackling something really practical in patent law, specifically how inventors can sometimes get around prior art rejections.
That's right. We're looking at the MPP, the Manual of Patent Examining Procedure, specifically Chapter 2100 on patentability.
And the section we're zooming in on is 2155.
Exactly. Section 2155, which covers using affidavits or declarations, basically sworn statements under Rule 37 CFR 1.130. It's all about overcoming prior art.
Okay, and this is particularly relevant now because of the America Invents Act, the AIA,
Yeah.
right? The first-inventor-to-file system.
Precisely. This section is a key tool for applicants under those FITF rules. It gives you a way to disqualify certain types of prior art.
So you get a rejection, the examiner points to an earlier article or presentation, and this rule might let you say, hold on, that shouldn't count against me.
Pretty much. It's a mechanism to explain why it shouldn't count, based on who made the disclosure or when it happened relative to your own actions.
And there are two main scenarios the rule covers.
Yes, broadly speaking. First, there's Section 1.130A. That deals with disclosures made by the inventor or by someone who, got the information from the inventor. Attribution, basically.
Okay, inventors' own work coming back to bite them, potentially.
Work derived from them, yeah. Then there's Section 1.130B, which is about situations where the inventor already publicly disclosed the subject matter before the prior art reference came out.
Ah, so showing you actually revealed it first publicly.
Exactly. And a key point here, which often surprises people, is that these declarations don't necessarily have to prove the prior art reference was enabling.
Meaning it didn't have to teach someone exactly how to make and use the invention.
Right. The focus for these declarations is usually on establishing who the inventor was relative to the disclosure, or establishing the fact and timing of your own prior public disclosure. You need evidence, of course, but not necessarily evidence of enablement in the declaration itself.
Interesting distinction. So it's more about ownership and timing under the FITF rules.
That's a good way to put it. It's about fitting the facts into the exceptions allowed by the AIA.
Can you give us a taste of how this plays out, like some examples?
Sure. We can look at a classic case, a hypothetical case involving a researcher and their student, and maybe another one about, say, a conference presentation versus a later publication by someone else.
Great. Let's get into that first scenario then. Section 1.130A, dealing with disclosures from the inventor or derived from them.
Okay. So, Section 1.130 lets you disqualify prior art if you can show it describes subject matter that originated with you, the inventor, or someone who obtained it from you.
How does that work in practice? You mentioned an example.
Yeah, the MPEP uses a good one with, let's call them Enwisha and Bob. Enwisha is the inventor, Bob is her student. They co-author a journal article disclosing subject matter, let's call it X.
Okay, standard academic practice.
Right. Then Enwisha files a patent application claiming X. But the examiner rejects the application, saying that very journal article under Section 102, A1, saying it was publicly available before the filing date.
Oh, wow. So her own work is used against her.
It happens.
Oh.
But Section 1.130A provides the solution. Enwisha can file a declaration.
What did she say in it?
She'd state, under oath, that she alone conceived the invention X. And crucially, she needs to provide a, quote, reasonable explanation about Bob's contribution.
Like what? Maybe Bob just ran experiments she designed or helped write it up?
Exactly. Something showing Bob contributed to the article, but wasn't an inventor of the claimed subject matter itself. If the explanation is reasonable, the MPT says that declaration should be enough to disqualify the article as prior art against her claim.
So it neutralizes the reference by attributing the core inventive concept solely to her.
Precisely. It establishes the necessary inventorship link required under the FITF exceptions.
But that reasonable explanation part sounds important. You can't just say, I invented it, Bob didn't.
No, definitely not. The MPP is quite clear, and case law backs this up. You mentioned Emmerchem Holdings v. Volkswagen earlier. That case reinforces it. Mere conclusory statements, just asserting inventorship without context, they aren't enough.
You need to actually explain the circumstances. Why was Bob listed as an author if he wasn't an inventor of that specific subject matter?
Correct. You have to provide that narrative, that context to make the assertion credible. It needs substance.
Makes sense. Okay, let's move to the other mean scenario, Section 1.130B. This is about the inventor's own prior public disclosure, right?
Yes. This is where you argue that even if there's a prior art reference out there by someone else, it shouldn't count because you, or someone who learned it from you, already publicly disclosed the same subject matter before that reference came out.
So this is about beating the reference to the punch. publicly.
Kind of, yeah. Let's use that virtual conference example. An inventor presents their invention online clear public disclosure. A month later, maybe, a third party publishes an article on the same invention.
Okay.
The inventor then files their patent application. The examiner finds the third-party article and rejects the claims based on it.
That feels wrong. The inventor disclosed it first.
And Section 1.130B is how you fix it. The inventor files a declaration stating they publicly disclosed the same subject matter at that virtual conference, providing the date, which was before the publication date of the cited article.
And that works even if the conference presentation wasn't super detailed, like maybe not enabling.
Correct. Again, enablement of the prior disclosure itself isn't the requirement for the declaration. The declaration just needs to establish the fact of the prior public disclosure of the same subject matter by the inventor.
But you still need proof, right? You can't just say you presented it.
Oh, absolutely. Evidence is critical. The MPP stresses this. You need supporting evidence for that prior public disclosure.
What kind of evidence works?
It could be dated presentation slides, conference programs listing your talk, maybe your recording if one exists, website archives showing the event details, even declarations from people who attended virtually and saw the disclosure. Anything that corroborates your claim about the disclosure and its timing.
So concrete proof is non-negotiable.
Definitely. The stronger and more verifiable your evidence, the better chance your declaration has of being accepted.
Okay, this is clarifying. So if we pull back a bit, what are the absolute key things to remember about using these Section 1.130 declarations under the FITF system?
Well, the number one thing is their purpose. Either attribute the disclosure back to the inventor under 1.130A, or establish the inventor's own prior public disclosure under 1.130B. It's all tied into those specific AIA exceptions.
And we've hit this point a few times, but it seems crucial. The declaration itself doesn't have to be an enabling disclosure of the invention.
Correct. It's about establishing the source or the timing of the information relative to the inventor's activities.
And this is the other big takeaway. Clear explanations and solid evidence are vital. No shortcuts.
Absolutely none. Whether you're explaining why a co-author isn't an inventor of the claim's subject matter or proving you presented at that conference, you need detail, context, and proof. That Emerchem principle applies. Assertions alone won't cut it.
You have to connect the dots for the examiner, showing how the facts fit the legal exception provided by Section 1.130.
You've got it. It's about using the rules effectively to navigate prior art that might seem problematic at first glance, but actually falls within one of the AIA's grace period or attribution provisions.
This has been super helpful. So just to recap for everyone listening, if you're under the first-inventor-to-file system and get a rejection based on prior art, Section 2155 and Rule 1.130 might be your friend.
They can be, yes. If the prior art came from you or someone who got it from you, look at Section 1.130A.
And if you publicly disclose the invention before the date of the cited prior art reference, then Section 1.130B is the one to explore.
Right. And in either case, remember, explain clearly and provide strong supporting evidence. Don't just state your conclusion.
Good advice. Definitely something for inventors and practitioners dealing with the AIA to keep in their toolkit.
For sure. And it's worth remembering this is just one specific section, 2155.
Yeah.
Chapter 2100 on patentability is huge, and there's lots more in the MPP we can explore.
We will certainly do that in future deep dives.
And before we wrap up, we really want to give a special thank you to Mike Shepard. He's the creative director who envisioned and organized this whole educational series. His work has been fantastic in helping make complex stuff like patent law a bit more accessible.
Hear, hear. Now, we do have our necessary disclaimer. Please remember, this summary was put together using AI tools, things like ChatGPT and Notebook LM. While we aim for accuracy, there could be errors or omissions.
That's right. Think of this as general educational info. It is definitely not legal advice, and it's no substitute for formal training or consulting the official sources.
Absolutely. For any specific situation, you really need to consult the official MPEP itself, talk to a qualified instructor, or get advice from a registered patent attorney or agent.
Okay, and finally, something to chew on. Thinking about how much we share online now, social media, blogs, videos, you name it, what kind of new evidence do you think will become really crucial for proving prior public disclosure under Rule 1.130B in the future?
That's a really interesting question, given today's digital world. Something for you all to think about. Thanks for joining us on The Deep Dive.
We'll catch you next time.